Hi everyone, we have a fairly technical case law matter to work through in this week's dispatch video, and it concerns time limits for presenting claims to the Employment Tribunal. So putting to one side the government's proposal is to increase the time limit to 6 months for most claims, focusing on the current position at law and the most common time limit in an unfair dismissal claim is 3 months from the date of termination to issue that claim at the tribunal. And those tight timescales have caused quite a few issues over the years for employees and practitioners as well. Now, the 3 month time limit is complicated by the fact that employees are now required to contact the conciliatory body ACAS prior to lodging a claim. The aim of that is to try and conciliate the matter to keep it away from the tribunal. And once an employee has contacted ACAS, the clock stops in terms of limitation. So if an employee conciliates through early conciliation for 6 weeks, the clock is stopped for 6 weeks. The employee adds that on to the end of their 3 month limitation period and then can calculate the last date on which a claim can be issued. Now, in a very recent case, the issue before the tribunal and ultimately the Appeals Tribunal was what happens where an employee contacts ACAS prior to the termination date. So we know the limit runs for 3 months from termination date and the clock is stopped for any period of time in conciliation, but is that clock also stopped for a period of time where an employee contacts ACAS prior to dismissal? This was particularly important in this case because the employee submitted her claim on what she believed was the very last day before limitation expired. The Employment Tribunal said that she was out of time because their view was that any time spent in early conciliation prior to the termination date doesn't count. So you can't use those days that you've been in early conciliation to extend limitation. The employee appealed to the Employment Appeals Tribunal, and thankfully the Appeals Tribunal agreed with the tribunal and agreed with the employer. So this is a case that demonstrates timescales in employment tribunal cases are very tight, and the employment tribunal will not extend time where the legislation doesn't allow it to do so. The employee's fallback argument was that it wasn't reasonably practicable to submit the claim in time, and this is at the tribunal's discretion, something that they can use to allow a claim to be presented out of time. The Appeal Tribunal's finding on that point was that it was absolutely practicable for the claim to be submitted within that reasonable time limit. She was also legally represented, so it would have been sensible, given that this was quite a confusing and untested point in law, for the claim to have been brought much earlier. So from a business's perspective, this does provide some comfort that the deadlines are not going to be extended beyond that set down in the legislation. From a practitioner and claimant perspective, it's important that any time that an employee is engaged in conciliation prior to a termination date is not counted when calculating when to present a claim. So that's quite a technical one. It's also on tribunal litigation, which is quite unusual for my videos, but if you do need any assistance on this or anything in relation to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.